ESG litigation risk is a real and growing issue. While financial damages are of course in play, the potential damages and impact on an organization's strategy and reputation are also potentially significant. Moreover, ESG litigation can be brought through many different venues and often involves novel applications of law, making this a critical area for in-house counsel to monitor.
Let's first take a step back and think about where ESG litigation risk might arise. This isn't just confined to litigation claims themselves. There are many risk areas where issues arising could lead to litigation. The risk of inadequate ESG governance, for example, is pretty obvious. If you don't have systems and frameworks within an organization for proper governance around ESG responsibilities and requirements, there's every chance that things will not get done or may go wrong. When things go wrong, this can lead to complaints, which could be complaints to the organization itself, to a regulator or other public body, or to a national contact point for countries that adhere to OECD guidelines. In regulated industries, this can also lead to regulatory action, and we've seen increasing focus of regulators on ESG rules and regulations. Complaints and regulatory action are often a precursor to litigation. Today, we'll be focusing on litigation risk itself. We'll look at key issues arising in the US, APAC, the UK, and Europe, and provide some practical advice on how to mitigate exposure and manage these risks.
In the United States, ESG litigation is heating up. Companies have been under increased scrutiny from investors, consumers, and government agencies alike over ESG issues. Pressure comes from both sides. On the one hand, some investors, consumers, and other stakeholders demand that companies give more focus to ESG. But other stakeholders question whether companies should be spending time and energy on ESG matters at all, arguing that ESG practices run counter to the duties of fiduciaries to maximize the profits of their investors. Both sides have sought and will continue to seek relief through litigation. There are three key areas in which we expect to see increased litigation and for which clients should examine their exposure. 1. Greenwashing. Companies have expanded their assortment of green offerings in response to increased consumer demand for environmentally and ethically sustainable products. This has led to a rise in lawsuits alleging that companies are misleading or deceiving consumers through their claims of environmental sustainability. Household names have faced litigation over claims of being, quote, carbon neutral. To avoid litigation risk, companies should be cautious around using the terms green, clean, sustainable, or similar claims, and understand the potential exposure that arises from using this type of advertising. Relatedly, companies may face green hushing claims when they keep private information about their sustainability goals. 2. Diversity, equity, and inclusion. Companies face increasing exposure to employment discrimination and shareholder derivative actions relating to DEI. On the one hand, employees and investors have targeted the lack of diversity on corporate boards and leadership positions, discriminatory hiring and firing, and misleading statements about commitments to diversity. These lawsuits typically allege that the corporation's directors breached their fiduciary duties by failing to ensure the corporation complied with anti-discrimination laws, or by authorizing false statements in public materials regarding the corporation's commitment to DEI. Companies are being challenged to achieve their published diversity targets in terms of board membership, C-suite composition, and advancement opportunities. On the other hand, we've seen an increase in claims alleging reverse discrimination because of companies' DEI commitments. This is a landscape we are watching closely, particularly in light of the Supreme Court's recent affirmative action decision and the chilling effect it may have on DEI efforts. Companies should consult with employment counsel to ensure their DEI initiatives are legally compliant and should be cautious around overstating their DEI goals and results. we have a task force led by former acting Solicitor General of the United States, Neil Katyal, that has advised multiple companies on how to navigate these rulings. 3. Proposed SEC Climate Disclosure Rules. The SEC Climate Disclosure Rules, if finalized, would require companies to disclose climate risks in much greater detail than is currently required. Companies may be required to disclose their climate risk management processes, and in some cases, this could include the quantity of greenhouse gas emissions in the company's entire value chain. Increased disclosure requirements increases the risk that a company's statements can be shown not to align with the company's actual actions or results. This could open the door to increased litigation risk under state false advertising laws or from shareholders through securities class actions claiming the company's disclosures are false. State attorneys general and legislatures. In the United States, we also see politicization of ESG issues, resulting in attacks on ESG initiatives from various actors, including members of Congress and state attorneys general. Some attorneys general are opposed to pro-ESG policies. They might claim that companies' actions on ESG, including both social and environmental issues, breach fiduciary duties and violate other laws. This point of view has manifested primarily in the form of warning letters and requests for information through civil investigative demands, subpoenas, and informal letter requests. In the same vein, some state legislatures have proposed or enacted anti-ESG legislation or initiated anti-ESG investigations. These anti-ESG measures are often aimed at preventing state fund managers from considering ESG factors when investing state funds. For example, 26 state attorneys general and private plaintiffs brought suit in the Northern District of Texas to challenge the Department of Labor's new ERISA regulations on ESG investing. The primary concern raised by the plaintiffs is that the new rules promoted ESG investing at the literal expense of retirement plan beneficiaries and did not require fiduciaries to act with the sole motive of promoting the financial interests of plan participants and their beneficiaries, as is required under ERISA. In a decision earlier this year, Judge Kaczmar granted the Department of Labor's motion for summary judgment and upheld the new rules. Companies operating in states with documented hostility toward ESG priorities should be aware of the risk and tread cautiously when implementing ESG measures that could impact state funds.
Before we start, when people ask about what is happening in Asia, people should realize that, firstly, it is not the equivalent of the European Union, which legislates binding ESG-specific laws and regulations. To put in context, Asia has a landmass 4 times that of Europe, and it comprises countries which are politically and culturally very diverse. It is therefore impossible to look at the ESG litigation risk for Asia in the time given. We propose to look at 2 of the most important jurisdictions for international investors, China and the Hong Kong Special Administrative Region. There are no uniform ESG-related laws and regulations in China and Hong Kong, despite the fact that Hong Kong is politically part of China. China's laws and regulations in this regard do not apply to Hong Kong, and it is therefore dangerous to assume that the 2 places face the same litigation risk. In Hong Kong, ESG-specific legal and regulatory developments have been centered around the financial services sector, particularly the funds industry and listed companies. But even within these sectors, our assessment of ESG litigation risk in the short to medium term is low to medium, and if there ever is litigation, it will most likely be regulatory investigations and litigation for misrepresentation or mis-selling involving ESG funds or disclosures that listed companies are required to make. This is because, firstly, there is no class action in Hong Kong, and secondly, the regulator's enforcement priority to date has been on education, establishment, and alignment of standards, rather than launching investigations or taking people to court. One thing to bear in mind is the external-facing nature of Hong Kong's economy and its role in global trades, which means that companies based in Hong Kong could potentially be impacted by the ESG litigation risk emanating from the US or EU. Moving on to Greater China, similar to Hong Kong, there have been few ESG-specific laws and regulations. Like Hong Kong, China already has a relatively comprehensive menu of laws and regulations in its existing arsenal to enable litigation to be pursued against, for example, greenwashing under misrepresentation and/or fraud. The existing anti-competition law, consumer rights and interest protection law, securities investment fund law, and advertisement law are examples where untrue green claims can be pursued. In the short term, there is a fairly commonly held view that litigation from the government is likely to be low, as China is still trying to strike a balance between economic recovery and ESG commitments when China comes out from COVID. Compared with Hong Kong, it is relatively more challenging to assess ESG litigation risks, as regulatory enforcement and the judicial system there are less transparent, and the agenda of the law enforcement agencies is viewed by some as closely linked to the temperature of Sino-US relations. Foreign companies based in China may therefore run an extra layer of risk when enforcement actions viewed as politically driven are taken by foreign governments or entities against Chinese companies.
Moving now to Europe. The ESG litigation and regulatory landscape in Europe and the UK is subject to constant change, and that is set to continue. Litigants are taking more risk and being more creative in the cases that they are bringing, particularly in relation to climate litigation. And that means organisations need to be alive to and manage this risk, given the potentially huge sums in issue. Just recently, for example, the European Central Bank Supervisory Board Vice Chair urged lenders and their clients to implement credible, Paris-aligned transition plans to mitigate the rising risk of climate lawsuits. Let's focus on environment and climate-related cases and look at some of the ways in which these claims are being brought in Europe. First, disclosure laws are an obvious ground on which greenwashing claims can be brought. If laws require disclosures to be true and not misleading, and organisations make statements where their green credentials are inflated and investors rely on this and suffer loss as a consequence, this can provide grounds for claims to be brought. Second, the French Duty of Vigilance law is a pioneering law which requires large French companies to publish an annual vigilance plan, which must establish effective measures to identify risks and prevent severe impacts on human rights and the environment resulting from the company's actions, together with the actions of its affiliates and certain subcontractors and suppliers. NGOs have brought a number of cases in France pursuant to this law on impacts such as environmental pollution, workers and trade union rights, plastic use, deforestation, and finance to fossil fuel companies. Third, human rights arguments have been used successfully in a number of cases in Europe. The Agenda decision in the Dutch Supreme Court found that the Netherlands' emission targets failed to meet its human rights obligations. And in September 2023, the European Court of Human Rights in Strasbourg heard a climate lawsuit brought by 6 young Portuguese against 32 European nations, arguing that countries have violated their human rights by failing to reduce greenhouse gas emissions in line with the 1.5 Celsius Paris Agreement goal. Judicial review has been used in the English courts to challenge the lawfulness of decisions by public bodies. Some claims have been successful, some have not. But the fact that they are being brought means that decisions will be subject to public scrutiny, and this can, in and of itself, bring about behavioural change. For example, NGOs have brought climate-related cases against UK government bodies, including challenging the effectiveness of carbon budgets, which form part of the UK's response to the Paris Agreement, and challenging the decision to approve the UK's investment in liquefied natural gas project in Africa. Permission to bring a judicial review claim was also sought by an NGO against the UK Financial Conduct Authority, challenging their decision to approve a prospectus for the IPO of an energy company on the grounds that the prospectus did not adequately disclose the risk associated with the company's plan for a new oil and gas, which, it was argued, appeared to be fundamentally incompatible with global climate goals. Finally, it's important to note the well-known and innovative use of the English shareholder derivative action by Client Earth to bring a claim against an oil major's directors. Client Earth sought permission to bring a claim alleging that the directors had breached their duties under the UK Companies Act with respect to setting appropriate emissions. The court has not permitted the action to proceed, and costs were ultimately awarded to the oil major, highlighting the fact that risks also exist for shareholders and NGOs in bringing such claims. One note on all these cases, and this is just a selection, there are many others, is that they are being brought by ordinary people who care about the environment and by NGOs taking a principled stand who are not driven by monetary concerns and whose primary purpose is to bring about changes in behaviour. Given that paradigm, it seems highly likely that these parties will continue to innovate and search for new and effective ways of bringing these claims in the future.
So regardless of jurisdiction, how can organizations who are making efforts to align their business with climate-related goals and implementing net zero transition programs try and mitigate the risks of ESG litigation? The organization's governance design and operation should specifically take ESG requirements and aims into account. Having systems and frameworks in place to govern ESG-related processes and decisions, and clearly assigning responsibility for ESG within the organization will help to provide appropriate process, analysis, challenge, and decision-making. If the organization has put in place ESG-related processes, for example, in relation to investments for green or sustainable funds, make sure that staff are adequately trained, that the processes are followed, and that accurate records are kept with supporting evidence which backs up decisions reached. Keep abreast of regulatory and legislative changes. Understand what the requirements are and comply with them. Understand that ESG-related risks arising from specific products and services provided by the organization. You can't mitigate risks that you're unaware of. Publications that include statements and reporting on climate-related and other ESG matters should go through verification processes that confirm the accuracy and completeness of the information included in the publication. Appropriate context should be included, so to provide a balanced and accurate picture. Use external reviewers to monitor progress and continuing accuracy. Even if these steps won't necessarily stop claims from being brought, they will be extremely helpful if you ever have to defend them.